Well, good afternoon, everyone. I'm happy to see so many people interested in the probate process. Again, my name is Karren Moore-Jordan. I'm an attorney with the Housing and Economic Rights Advocates in Oakland. And I'm basically the presentation is going to talk about the steps involved with going through probate. So with that, we'll go ahead and get started. I can get okay. HERA, or the Housing and Economic Rights Advocates, is a California statewide organization, a nonprofit that provides free legal advice or low-cost legal advice, and it covers just about any area you could think of, economic abuses, housing, foreclosures, difficulty with working with servicers, predatory scams, debt collection, and landlord-tenant issues, and now probate. This is a new area for HERA. There's a lot of interest in it. There's a lot of people end up in this situation, don't know quite what to do or where to turn. What happens to our stuff? Just because we're no longer here, we know that these things still have to be dealt with. And so probate is the process that helps our loved ones figure out what to do with all of our stuff legally, our homes, our special collection items, jewelry, anything that we have, both personal property and real property, has to be passed on to others. Probate is a court process for transferring those assets you own at death to those that are legally entitled to receive them. And that depends on whether or not there's a will, and the will says who's to receive what, or if there isn't a will and someone dies without a will, without a trust, which is called intestacy, there's a probate code section that lays out who's to receive what in the event of your death and you die without any kind of plan in place. It's a system to make sure that your assets go where you intend for them to go. And finally, it's a plan to transfer your assets. Oops, sorry about that. When there is no plan in place. Now, probate is not the only way that we pass our assets on. There are plenty of non-probated items that don't go through this process. And the most common one are life insurance proceeds. So when you take out a life insurance policy, you specify the beneficiary who's to receive those proceeds, and they go directly to that individual or charity or organization. Those items do not go through, those proceeds do not go through probate. Property that you've placed in a trust does not go through probate. Property that's held in joint tenancy with the decedent does not go through probate. You can also specify bank accounts to be pay on death. So once you die, the person you have identified, designated to receive the amount of money that you have left in your checking or savings account will go to those individuals directly. There's no probate. HERAs and other retirement benefits, again, there's somebody who's been properly designated as a named beneficiary. They don't go through probate. We now in California have what's called a transfer on death deed, where you actually can record a deed for your property, and that deed says, upon my death, this property passes to a specific individual or a group of individuals. There's also what's called a small estate administration in California, and that qualifies property that's worth less than $184,500 to go through a different process, which is an affidavit or a very shortcut type of probate process with the court. And then, of course, community property passes directly to the surviving spouse or domestic partner. So these are all items where you do not need to go through the probate or court process. This gives you an idea of the phases of the probate process. And I'm going to go into each one in more detail. But generally speaking, you can see at the top how long the process is. And this is an ideal situation. Probate is a very long process, and it takes a minimum of 12 months, and more than likely anywhere from 18 months to 2 years. But the initial part of the process is someone being appointed to manage the estate and administer the decedent's assets. Part 2, or phase 2, has to do with inventory and appraisal. That means locating all the decedent's assets and preparing them for appraisal. And then finally, the last phase has to do with actually distributing the assets that were in the decedent's estate once the court issues an order that says these items will now be passed on to the named individuals. So in phase 1, that's where if there's a will, the will say who's to be the executor. And this executor, or if there is no will, the other name for the person would be an administrator or personal representative, has to be appointed. And that starts with either, like I said, a will, or anyone can come forward who has an interest in the person's estate and ask the court to appoint them as the administrator. It's also during this phase that you'll estimate the value of the estate, locate the names and addresses of all the beneficiaries and the heirs. If there is a will, it has to be lodged with the court, the original copy. And then you prepare the petition for probate. You have to give notice to all of these heirs and beneficiaries. And you also have to publish a notice of hearing in the newspaper. All of this has to be done prior to even becoming the appointed representative of the estate. And again, this generally takes between 1 to 4 months. And a lot of it has to do with the court calendar and how soon you can get on the docket. Once the petition is completed, you go to the court, it gets filed. The petition will be granted if all the proofs of service have been filed. Everybody who's entitled to notice has received the notice, or at least you say you mailed the notice to them. The judicial counsel forms have been completed correctly, and the court has received the proposed order and any other documents at least 5 days before the hearing. A lot of times, if any of these items are missing or incomplete, your case will have to be continued for another month or so. Phase 2, which is the inventory and appraisal, you have to locate all of the assets. That means if there's real property involved, you have to have the deeds to the properties. You will evaluate other items that are in the home that may be of significant value, such as jewelry or antique cars, whatever those items are, stocks, bonds. You have to get a list of all of these assets. You need to set up a bookkeeping system. The court expects to know every dime that came into the decedent's estate and every dime that goes out. So that is so important. That really holds up a lot of people in this process because they don't keep good bookkeeping records. You have to identify all the expenses of the estate. The administrator is entitled to reimbursement. When you first file that petition for probate, there's a filing fee of $435. There's the cost for the publication in the newspaper. There are all these initial costs that are considered expenses of the estate that the administrator will probably have to pay for out of pocket, and the administrator is entitled to reimbursement. The court will also waive the court filing fee if it's too much of an economic hardship, but that has nothing to do with the newspaper publication. That will only cover the court's filing fee of $435. When you get your appointment, the court assigns a specific probate referee. It is this person's job to appraise real property and securities, so stocks and bonds. You must use this individual to do the appraisal. You do not get your own appraiser for this process. You have to notify all creditors that the probate is started, and if they want to put in a claim, now's the time to do it once the administrator has been appointed. You pay the decedent's debts, you close accounts, the utilities, the cable, credit cards. Some creditors get special notice, like the Department of Healthcare Services, for any Medi-Cal services that the decedent received. And you also have to prepare the inventory and appraisal and file it with the court. I put this slide in here just to kind of give a little more information. A lot of people are concerned about the Department of Healthcare Services and the fact that they have the right to recover the amount of money or for benefits that they provided to the decedent. But Medi-Cal will only go after property that is subject to probate. So all those other things I mentioned in the beginning about your HERAs, life insurance proceeds, property held in joint tenancy, those items don't go through probate. And so the Department of Healthcare Services will not attach a claim to those things, only the assets that are going through probate. Estate recovery only applies to benefits that the decedent received after their 55th birthday, or someone who's been determined as permanently institutionalized, which would be an individual who's been receiving Medi-Cal most of their life. Those individuals are also, whatever assets they might have at death that go through probate, Medi-Cal can go after. Most Medi-Cal members will not owe the state anything, but of course there's a little caveat to that. And basically the Department of Healthcare Services will not file a claim if the decedent is survived by a spouse or registered partner, if the decedent is survived by a child who's under the age of 21, or if the member who received the benefits has a child who's blind or permanently disabled. And the Department of Healthcare Services will also waive a portion or all of their claim if a substantial hardship exists. Some of you might have heard about probate advances or getting an advance on your inheritance. There are a lot of companies out there who will, it's not considered a loan technically in the financial world, but it's pretty much what it amounts to. And they are out there who will provide cash while you're waiting for a probate to close, because a lot of the time the process is so lengthy. But these companies charge a lot of fees and the money comes at a very high cost. And so it's recommended that if you can wait for the distribution, that you do not use these companies, because time is the element that's built into them. So for example, you might think, oh, I'm gonna just get this $5,000 while I'm waiting for the probate to close. It'll close in a couple of months. Well, a couple of months turns into a year, and the clock is ticking on those fees all of that time. So when you compare these probate advances to what you might be paying for a mortgage or a car loan or credit card interest, their interest rate can be translated into almost 90%. It really is not worth it if you can avoid using one of these companies. Finally, when we get to the final distribution stage, you have to prepare accounting schedules. There's several. Again, as I mentioned earlier, the court wants to know every dime that goes into the estate, every dime that comes out. And so you have to prepare a schedule for the income, for the expenses, any reimbursements. If you sell property while you're managing the estate, they want to know about that. And it's a very detailed process, and that's why it's so important to start that bookkeeping right away so that you'll be able to put these accounting schedules together. You have to prepare the final tax return. In California, there's no inheritance or estate tax. And even when it comes to the federal estate tax, very few people are going to encounter this because it only attaches when the estate is worth over $13 million for individuals and $27 million for married couples. The petition for final distribution has to be prepared and filed with the court. You have to include a statement on the estate's solvency, where all the bills paid, where all the creditors taken care of. You have to prepare a proposed distribution schedule of who's supposed to receive what. And then you have to prepare a notice of hearing to give to all parties who have an interest in the estate, so they have an opportunity to make a counter argument about something, or they're not receiving what they thought they would receive, or so forth. And all of this has to be filed with the court. Then you'll have a hearing on the final distribution petition. It's at this time that you would calculate any fees that are owed to the personal representative / executor / administrator and the attorney, if you had an attorney, if you hired an attorney to help you. You have to prepare the judge's order for distribution, file the petition, get a hearing date. Every heir who receives something must sign a receipt for that, and those receipts have to be filed with the court. Once the court gives you the go-ahead with the order, you have to make distributions to the heirs, and it's at that time that those receipts would get signed. You get each one signed, return the original wet signed copy with the court, and then finally prepare and file your petition for final discharge. This is a breakdown of the statutory fee in California. The fee does not change if you hire an attorney. It's calculated based on a formula, and the personal representative or the administrator / executor and the attorney receive the same fee. Attorney's fees have priority over any beneficiary distribution. So all the expenses of administration must be paid first, and then the beneficiaries receive their share. And as you can see, by way of example, if you have an estate that's worth $500,000, the statutory fee that gets calculated is $13,000 for the attorney and for the executor. Now, of course, the attorney can always take less, and the personal administrator can always waive their fee, but this is how it's calculated. And as you can see, it goes up. It goes up depending upon the value of the estate. And so that pretty much covers it. One of the strongest takeaways I would like everyone to remember is you want to avoid this process. Originally, probate was designed to protect individuals who are vulnerable at a time when they're grieving. But unfortunately, the process has turned into something very lengthy and very expensive. And the best way to avoid probate is to create a trust and use the other non-probate tools that I mentioned earlier, such as pay on death accounts, transfer on death deeds, or joint tenancy ownership. And so it's well worth spending the time and money to create an estate plan now, rather than leave your property and your loved ones with the headache and expense of going through this probate process. And it can be avoided. So I don't know if we would like to entertain some questions or comments. What about multiple state? I'm not sure what that means. If you're asking if you have property in California and property in another state, there have to be two different probates in order to handle a situation like that. You have to do a probate in the second state as well. Okay, it's where the property is. If your father had property in Florida, that's where you'll have to do a probate. There's a question here about compensation for the administrator. That refers to this line right here. Oops, sorry, guys. The person will be compensated the same amount that the attorney receives.
I had a brief question.
Okay.
Heather, could you clarify what happens if there's a dispute among family members about who should be the administrator or the executor?
Well, there's a probate code section for that too. There's a system of priority, who has, who should be the administrator. It always starts with closest family members, spouse, children, and just goes down the line. Even a creditor could be the administrator of the estate, but that person is way down at the bottom of the list. So that's how that gets decided. And ultimately, if a decision can't be reached, the judge will just appoint a public administrator or an independent third party to do it.
I see.
Let's see. Are there any forms that HERA can provide? All of these forms about probate are online. Just go to the Superior Court in your county online, or you can check out the Judicial Council website. All of the documents are right there. What if someone wanted to purchase the real estate listed in the probate? You have to have the court's authority to sell real estate in a probate. If the person has a will, they can state in the will that my executor has the authority to manage my estate without complete court supervision. But if there is no will, then you have to ask the court's permission to sell the property, and it becomes what's called a supervised sale, which means bidders have to come forward. The court will not accept less than 90% of the appraised value for the sale, and it has to be approved by the court ultimately. I also forgot to mention too, when there's no will, a lot of the time, the personal representative will have to get bonded. And this is a requirement that the court makes as well. Even when there is a will, sometimes, if the administrator lives outside of California, the court will still require that the administrator be bonded. Let's see. Does probate ever expire? Answer no. Property can never pass on to someone else legally without that process being completed. But the court will speed things up if it finds that the administrator is taking too long. And you could be removed as the administrator and a neutral third party put in the place of the person who's taking too long. I have seen probates go on for 10 years. They last a long time sometimes. But the courts are trying to get better about that and enforcing the hand so these things can be wrapped up, because it ties up property for so long. Recommended practice guides. If you're looking for a source to walk you through this process, Nolo Press has an excellent guide out, and it's called How to Probate an Estate in California. It's very good. What if there's no property, but after 5 years you find out there was investment funds? Can I still present probate court documents to retrieve the funds? That would be a tricky one, because that's part of your job as the administrator, to make sure you have identified all the assets. Now, of course, some things show up after the fact, but you'd have to file probably a new petition to deal with that. or some other, maybe an ex parte petition might work. I'm not sure how the court would deal with that. Let's see, I see another question. If the beneficiary lives outside the United States, that doesn't matter as long as you have a contact address and you can get in touch and that person can receive their share of the estate and sign the receipt. It doesn't matter where they live. Let's see. Well, I addressed the question about finding out funds later. You're going to have to go back to court and do another petition. It may not be the full-blown probate petition, but you're going to have to go back to the court to ask about that. Also, the amount of the funds will make a difference. If it's, a nominal amount of money, it'll probably go very quickly with an ex parte petition and just divide it up equally between the heirs. Of course, now that you're finding out about more assets, that changes the value of the estate, which changes the statutory fee. So you may have to do some tweaking around that if the attorney, if there was one involved, is entitled to more money. Let's see.
I see a question that says, what's the best route if the parent has no property, just money in the bank? Do we still need a trust?
Let's see. Well, again, as I mentioned, if the estate is worth less than $184,500, it doesn't go through probate. You can use the affidavit procedure, and that involves getting an affidavit. It states that you are the only one entitled to this property, money, whatever it is. No one has a higher claim than you, and that the entity, whether it be a bank or investment firm or somebody, or even a private individual, you are holding this property, and you now have to give it to me. That affidavit has to be notarized. And again, it's about how much it's worth. So you wouldn't have to go through probate, and a trust is not always necessary, particularly if you use some of the other things I mentioned. If we are talking mainly bank accounts, then why not just make them pay on death? Makes it real simple.
On that point, can I ask you a question?
Sure. I also see a new message here real quick.
Just on the calculation of that 184,000, does that include the assets in the trust, or can you exclude those assets?
Trust assets do not go through probate.
Right. So can you exclude?
So they're not included in that number.
They're not included in that number.
No.
Excluded. They're excluded.
Correct.
Okay. So it's just anything outside of the trust.
That's right.
Okay. Thank you.
Let's see. Let me see. We didn't know we have various types of accounts. Yeah, that's unfortunate when people have taken money out of the estate and you're finding about it later. And 5 years is a long time. A lot of the time, you have just a short period of time before the statute runs on those type of claims. But you probably could pursue something civilly against that individual, not necessarily within the probate court. Does that make sense?
There must be a process in probate that allows an executor or counsel plus the executor to go to court and ask for guidance or advice from the probate court on how to handle a unique situation. You
can always ask for a petition for instructions.
And how does that?
Called.
Is that what it's called? Is that like making a motion in civil court?
Not exactly. What you would do is you fill out the like a declaration, and you would explain the situation to the court and ask for the court's instruction about how to proceed. A lot of the time the court will tell you, you should try to figure it out unless it is something very unique. They're not
Are,
going to give basic instruction like, what you need to tell the bank when you go to the bank or something like that. It has to be pretty unique and a little bit complicated.
are there judicial council forms for that, or do we just cook up our own version?
No, that's why I said it's a blank form, like a declaration. Just trying to run through here to see if there's something else I wanted to mention. This is a list of things that do not go through probate. And it makes a lot of sense for some families to just put all their assets in these types of accounts. A trust is not the answer to everything. Let's see. That's right. A trust will avoid a lot of these hassles. You will not have to go to court and file a petition. You will not have to pay the attorney's fees. You will not have to wait. Generally speaking, a trust can be wrapped up in a couple of months as opposed to a couple of years with probate. Where can we find the family order of inheritance? Does an adopted child come before? All children, biological and adopted, are treated the same. So you do not have they are on the same standing and will receive an equal share in the estate. You would have to find that in the probate code section, but generally speaking, immediate family members take first, spouse, children. You only get into parents, siblings, typically if there are no spouse or children surviving the decedent. Let's see. If somebody dies, if a beneficiary dies before the probate process is complete, then whatever their share is passes to their estate. It doesn't automatically become community property. It goes into their estate. And again, what their estate is will depend on whether or not they had a trust or if they had a will. And if not, it would have to go through probate to be distributed to that person's heirs and beneficiaries. But the money will get passed on, or the asset, whatever it is. I have no idea about the state of Florida. I suggest you just go online and type in probate assistance for that state. I'm sure there's some organizations similar to HERA that are operating on that part of the world. Judicial council forms are all the same for all counties, but again, you do have to look to local forms also. Some local superior courts have their own rules for a few things. I see a question about special notice groups, and that's right. In addition to the Department of Healthcare Services, you have to give a special notice to the Franchise Tax Board, and I'm trying to think of how the name goes, but it is the state. Oh gosh. It has to do with anybody being incarcerated. It won't come to my mind right now, but there's a state agency that deals with people who are incarcerated. And if somebody who's incarcerated is entitled to a distribution of someone's estate, you have to notify them as well. Because the state will want to take that money to go toward any restitution that the incarcerated person owes. Does that make sense? You only have to notify them if you know for a fact somebody is in the prison system. Yeah, there are a lot of little things that have to be done. I'm always surprised. Well, I'm not surprised, but a lot of people say, well, what's the big deal? You just have to file some documents. Yeah, it is a big deal.
One question is, does HERA offer assistance in terms of estate planning?
Yes, we do. And it's on a sliding scale basis. I also do that. That's why I'm encouraging everybody to get a plan going. I know we all procrastinate about it. Nobody wants to think about their own mortality, but it is so worth the time and effort. So yes, you are free to call HERA and ask for assistance with your estate plan. We prepare all the documents. And again, it's on a sliding scale basis. It's not free unless you qualify because of income. Yes, as there goes to help resolve disputes. The court can let you know about that. They will require mediation if things get very sticky, and they do have a list of referrals. It's well worth it to try to figure things out amongst yourselves. Again, I thank everyone for coming, and I hope you got some useful information out of this. And again, feel free to contact HERA. Oh, great. It's right there in the chat. The website is very good at providing information as well. We are happy to assist. Thank you.